I would like to open this session, which is going to be, I'm sure, very professional and extremely broadening. But please, the gallery, stop chattering and come closer to us and start paying attention, please. Because if anyone wants to continue to continue our partnership, please, you have to abide by certain rules. How can you do without it? And I would like to say that I'm happy and I'm honored to introduce this new academic class to Mr. Pashin. And so because you read professor, research institute, higher school of economics, some member of the council, so the judge, a judge, etc. And I think that so it happens once in a while. As it happens once in a while, not very often, because so we talk. So, but there is, after all, in the Russian Federation, so professional, independent judges, and so you are meeting one of those today. Independent and professional. I'd like to thank. To thank him and so the citizens who know about him, and so God forbid that we have to go through those judicial tribulations in practice, but so the knowledge, the awareness that there is such a thing in Russia as an independent judge makes our lives easier and puts our hearts at ease. And so, please, over to you. Ladies and gentlemen, so the sooth, ethics, truth, so gnoseology. So out of the frying pan and into the fire, because so I came from Belarus. So then there is a campaign. For the jury and against the capital punishment, and so they still shoot the convicts. And so I was meeting different categories of people. So one of the meetings was at the Institute of Enhanced Studies and Training Courses for judges and the investigators. And then they asked me to talk about the admissibility of evidence. So I wish they hadn't done that, because admissibility, so they were kind of quiet, nice, happy, and so because they knew that they would be getting their certificates in half an hour, and so 1 o'clock lunch, and all these judges and investigators, and then we started to figure out their legislation about admissibility of evidence. And then all of a sudden it turned out to be very complicated, so they quarreled, so they missed the lunch, and then they made up, and then they quarreled again, made it up. And it was funny, but at those similar events, I had to comment the text of the criminal code of Belarus, but in all post-Soviet area, so the texts are the same, and the criminal law is the same, exception Georgia and exception Ukraine, but Kazakhstan, Kyrgyzstan, Belarus, Russia, so the criminal code is the same. So in some other states, so when they develop the code, so the scientists actually they participate in the development of the criminal code, and so they're trying just to put their textbooks into the law, and then so that they could later tell their students that the legislator agrees with their theory, and it turns out to be horrible. And for example, by the Russia Article 105. So what is the truth of evidence? So then the evidence, if they conform to reality, they are admitted as real, because there was no word truth. There was no word truth. So because they abandoned it, so there is no word truth. But always some objective truth come out. So then all the evidence is considered to be truthful if it conforms to reality. So that's the definition of truth or veracity. So then, do you think that the evidence can conform to reality or fail to conform to reality? So it can conform only to certain assumptions, to certain pronouncements. So, for example, so the protocol of search conforms to reality. What does it mean? So the next step, as I said to my the attorneys and investigators, criminal investigators. So are you learning, studying the environment with the help of what? So with the help of evidence, and the evidence with the help of reality. What do you compare evidence and reality? How you do that? So I could contain myself, and I spoke about my friend from St. Petersburg, who was a judge, and he was an extrasense. And then he said, so that's when I see a person who knows exactly whether he is guilty or not, a person who is being tried. So it means that for him, so all this process, due process, investigation, evidence, so it's superfluous. We don't need it because he knows the truth. Because the moment so has this wonderful insight. As he looks at the criminal, so he knows that he's a bad guy. So it's bad when the scientists write criminal codes in the Charter of 1864 of the Empire, Russian Empire. There was no. So in the criminal code there is no general part. So we say we're continental, we're like Germany. So but they don't have any general principles. They don't have it. But the criminal code was written in 1867, and still with some amendments is good today. So in 1878, and not in 1978, so it was under Hitler with amendments, and then after Hitler, so Hitler, all the amendments made by Hitler were taken out of the criminal code. So that's why the word about truth is not academic, it's practical, because under the pretext of truth in the criminal code, they want to add something else. For example, so there's a new draft of one of the deputies that appeared in the winter this year. So he wants to return objective truth about presumption of innocence. Because it's a fiction. It's a fiction of presumption of innocence should not work, but presumption of innocence can be applied only when a person was tried, and if impossible to find truth, then we can add presumption of innocence. But the case should be referred to more investigation until the truth will be revealed. And the court should not check the materials of the preliminary investigation, but the court should look for truth and fill up the gaps of the preliminary investigation. So then the Attorney General and the investigative committee so should look for truth. So this is the draft of the deputy. It's not about truth. It's about a follow-up investigation and not truth. About truth or about veracity, about sooth, forsooth. So about the Soviet theory of proof. Whatever the modern scientists were saying, but this Soviet theory lies as a basis for many constructions. The referenda, so improvement of the law, and it's the foundation. It's quite simple, straightforward. So they were Cartesian monks, as you remember. And Jesus, to the question of Pontius Pilate, what is truth, didn't answer anything. Bulgakov answered for Jesus in his blasphemous novel. So then this novel about Pontius Pilate. So he told, so your head is aching. So that's what, this is the truth. That's what he said to Pontius Pilate. And all you love, you give to your dog. And this is the truth. That's what Jesus Christ told Pontius Pilate. But Cartesians tried to find what Jesus Christ should have answered to this complicated, convoluted answer. And Cartesian monks, they found the answer that Jesus Christ should say that truth is the right related to life, the knowledge about the world outside us. Yeah. So the truth which conforms to reality. So outside us, and this is what the Soviet theory of proof is based. So which says that the goal of proof, the due process, is establishment of truth, as if the lawyers are archaeologists or historians, and then the Soviet lawyers say establishment of truth is a kind of, it's an inquisitive process, a scientific inquisitive process, and jurisprudence is something on the sidelines. So the specifics that we are learning this truth in a very concise framework of time with the help of special means. But then, thank God, the Professor Radkov, the former Attorney General, was writing in 1956. He wrote that our Soviet investigator and the judge, so they are armed with the Marxist theory. It means that if he failed to learn the truth, it means that he worked badly. But otherwise, so there are no barriers to establishment of truth. Truth does not exist. So then read Materialism and Imperial Criticism by Mr. Lenin, and everything just will fall into place. So the truth is obtainable. The truth can be methodologically obtainable if you work well. So then our scientists, so they start prolix discussions so on which issues we need to find the truth. And everyone just agrees that the truth is needed concerning the fact, the fait accompli. And for example, Ivanov, with his right hand, just got into the left pocket of Petrov, and so on, stole 3 rubles and the purse. And this is the issue of truth, and we need to establish that he stole this wallet, so containing a bus ticket and 3 rubles. So the act should not be accurately established, but it should be properly qualified and applied to a certain code of the criminal code. So the Article 158, which is theft, and this is it. So then you apply this action to a certain article. So then certain Marx, so when he was a Helen. So because the qualification ensues not from the action, but the true qualification ensues from the natural course of events, because the action which is not criminal is a criminal act. So that's why because criminality should expose the natural objective crimes. So because are you following me? Are you still with me? Are you still with me? Yeah. So, but our scientists, they are not going into that. You qualify the crime on the basis of what you got. But if you wrongly identify what happened, so then your qualification and application of the law will be correct as well. And that's why in our jurisprudence, so we have some hot heads. Usually I speak faster, but so we know this is simultaneous translation, so I have to speak slowly. And so some hot heads say that the truth, that the punishment should be truthful as well, and then they forget about so what the judge can do. For example, so can can the judge give mete out the exact punishment? Give or take a few days of imprisonment. I know some sly judges who got the amnesty order, so they mete out the punishment with accuracy in 1 month, because the amnesty status says that the amnesty is subject, the convicts up to 5 years of imprisonment. So if the judge wants the person to get out of the prison, so he gives 5 years or 4.5 years, or if he wants him to stay in prison for a while, he gives him 5 years and 1 month, and then he stays there for a month. But otherwise. Otherwise, a person cannot mete out the punishment exactly, because they don't have a yardstick to measure out the punishment. What's the difference between 5 years and 3 months and 5 years and 8 months? So the judge does not understand that. So this we have Osipov, Pakhmelkin wrote about that. But I think that they have not come any closer to it, and so this talk that the punishment should be truthful and objective. So the judge is trying to become a person who forecasts. So he prognosticates. So he says. So he's thinking out into the time frames of the punishment that should be relevant and commensurate to the crime committed, and gives 2-3 months more or less. So it means that the judge sees the truth in future, and he sees the truth in the past. So then, when we start to relieve him of his authorities, if someone freed him from custody and he eloped and he ran away, that happened in Gatchina in Moscow. So the judge is punished that he freed the person, but he did not forecast that the guy will take to his heels and run away. And that is why they taught the judges not to free the suspects. Because if the guy runs away, so there will be a problem for the judge. That's the truth. That's why they are always in custody. So you stay in prison. I'm not going to let you go. If you run away, it will be my responsibility. So the Soviet lawyers, they are discussing this, and so huge dissertations, theses, what kind of truth is learned with the help of criminal process, of due process. So the truth is the relative and absolute. So the absolute, Professor Ivanov killed Petrov, for example, but our lawyers, from 2 viewpoints, they invented 5 points of view. So then the truth in process, it's absolute. They say that in process it's relative. Some say it's absolutely relative or relatively absolute. The truth is, because we do not learn everything, but we learn only what is pertinent to the crime. So in one case it's relative, the truth is, and some absolute truth. And then that Professor Yakubov, the writing, can imagine that the philosophic categories are not applied to due process, and all these discussions about truth being relative or absolute, let the scientists, because the procedural guy say we don't need it. And in actual procedural work in due process, relative truth or absolute truth, you can play with it. It's not an instrument. And the most important from the Soviet course of truth, criteria of truth. So okay, we've learned certain facts. So Ivanov killed Petrov, but what are the criteria that we learned it right? And for this, so then our jurisprudence in the back pocket has a good answer. So where did it take this answer from? Certainly from materialism and the Marxist criticism. So our practice testifies to the fact that we understand everything correctly, because the practice, because Lenin was writing so public historic practice. So communism is all powerful because it's right. That's it. And it means that sooner or later everyone will live under communism, and then they will realize that the classics of Marxism wrote correctly. So then historic practice manifests itself when we don't need it, when we're already dead. and we cannot insist and show that, oh, you were right, but it's too late, we're dead. And our procedural guys, so they're talking about the public historical, they cannot say that. They say this is the practice of the law enforcement bodies. This is the criterion of truth. And then I was listening, and then I couldn't listen to anymore. And so I asked the lady, it was in the Moscow State University, she was the speaker. So what kind of practice do you mean? So the practice applied in 1935, 1937, so the mass purges of the people. That was the practice that was applied, and or the practice of the 50s, or another practice. The modern practice is to say which one is the truth, or the true practice. And so how do we figure out so which one is right? So there is a wise answer to that too. That so then the higher instances, they have the practice. So the higher we are on the hierarchical ladder, so the closer we are to the truth. And so the Attorney General, so the truth used to be in the hands of the higher court of the USSR. Then the truth went a little bit down. And so then the union collapsed, and the truth moved a little bit to the higher court, went down high court of Russia. So our truth is where our bosses are. Can you imagine that? And so that, and so we discussed with by the Russian attorneys. So they were certainly adherents of truth and sooth, but they wanted just to touch me on the raw. So probably you are an adherent of a bourgeois criminal process. And so when I was a young guy, I was reaching the rational essence of the bourgeois due process, criminal process. I was reading that. And so you know this, oh, you bourgeois bad guys. And so they start telling me, do you know that case of O.J. Simpson? So can you imagine O.J.? So Afro-American, a black guy, an actor, and a soccer player. So he was accused that he killed his wife and her former lover, so double. So this was the first order, homicide of the first. And so he was judged and tried, and the jury was made up of the colored people. So they said that he was not guilty. So they said that he was not guilty. And but they didn't stop. So they applied a suit as a civil procedural process, and they judged him responsible for the death of two people. So homicide of the first. And so where is your truth? How could you have done that? He either is a murderer or not. He killed or did not kill. But now they say he's innocent. He's innocent of the crime, but he's responsible for the death. So what is that? So I said. So then I was trying to explain that lawyers, like journalists, like priests, so they live in a virtual world, and in the virtual world everything is possible. Two truths and two truths are possible. So and in the legal world there are the fictions and presumptions. So what is a fiction? A fiction is something that doesn't exist, but everyone knows that it doesn't exist, but they take it as something that exists. So the most simple example is when if you left your apartment without telling the court, so then actually the order that comes to your old address so is considered to be handed to you personally, although physically you did not take the court order that you need to come to the court, and but it's considered to be physically handed into you, although it was just dropped into your mailbox, and so it exists and it doesn't exist. So the legal time flows differently, and. So sometimes it slows down, sometimes it goes faster, and sometimes it so the 5 o'clock tea, and so everyone is having 5 o'clock. So the time stopped, and so they're drinking tea until they burst from this tea, and so then the time stopped, and then started to tick again. So strange thing time is, and the time flows, and some stretches of time so that counted in, and some stretches of time are counted out. And how that's this one of the challenges. So the challenge of J. Simpson and truth or sooth was in the standards of proof. What is the standard of proof? There are 4 standards of proof. So according to civil cases, the standard of proof is the overweighing of evidence, and in criminal cases, it's beyond any reasonable doubt. So the standard of proof on J. Simpson case was beyond any. So it was not reached beyond any reasonable doubt in the criminal case, but the standard of overweighing of evidence on the basis of the same evidence was achieved in the civil process, and that's the point. That's why Simpson. So like Meshka Schrödinger, you remember, so that guy who is alive and dead at the same time, so is guilty and not guilty, killed and not killed. For the purposes of civil purpose, he didn't kill, but for the criminal case purposes, he didn't kill. Civil procedural, he killed. So now J. Simpson is doing his time for burglary, and so then and then Simpson, he's still doing time. Before he went to prison, he wrote a book, and so then the book titled "If I Had Done It," and then he explains how he did it. Okay, but since in legal reality it already says that he didn't do it, and you cannot try the same person for the same crime twice, then his book was not perceived as the admission to the judge. And so $2.5 million he made on this book, and so then and the aggrieved party, so they got this money, and so he had to go and to High Street and burglarize people, and now he's doing time because it's 2.5 years for robbery, and the money was taken from him.
So I couldn't help telling you about the truth based on Russian reality. It's all nice with O.J. Simpson, and we try to interfere with that trial. Why we did so? We had some satellites, tracking satellites, and they spotted his car close to the place of accident. The judge, rejected that Russian gesture of goodwill despite the reset of relations. But we demonstrated that we can see everything with the help of our spying satellites. So the Americans were impressed. And here comes the Sushko case, based on Russian reality. In Rostov, Sushko, being drunk, smashed the head of his neighbor with an axe. Then he carried the dead body to a barn, covered it with wood, returned to his apartment and continued drinking. And that's where he was arrested. He was tried in the court of jury in Rostov, and at some point the counsel for defense asked to remove the jury and discuss some legal issues. The counsel for defense said that we should remove from evidence the blooded shirt, and the conclusion that it was the blood of the deceased, and the discovery of that shirt in the apartment of Mr. Sushkov. The judge asked why, and the counsel for defense said that it was the coroner who investigated the case, while the shirt was removed by the police. And there was no certified transfer, so it was the excessive authority. So that shirt is to be excluded from the evidence, and a judge agreed with that statement. Jury was brought back, the trial went on, so there was the cross-examination. And the counsel for defense asked the way the forensic were interviewed. The interviewed said that with such a wound, the blood is very flows as a stream, and just look at the shirt of the accused. His shirt he was arrested in was clean, and it was not spotted with blood. The jury went for counsel for discussions, and they returned in 20 minutes, and they said that they didn't found the accused guilty. That's kind of a lacuna. And so what about the soothe? From the standpoint of evidence, the jury was right. But from the standpoint of truth, probably the culprit was released, the murderer was released. But if the jury had functioned without evidence, if they had based their judgment on the appearance of the accused, it wouldn't be justice. It would have been something different. So, under the circumstances, my position is quite simple. The trial may not establish the truth, but it resolves the case. So, then the next step, perhaps judges are looking for the truth. So, just try to imagine how they work. Ordinary people do physical exercises in the morning. When judges, after doing physical exercises, they read the judgments or court rulings. And what is interesting for me in those rulings, actually, I'm interested in seeing how judges articulate the scheme of their statements. And I would differentiate between the four methods which judges use, and with the help of which a judge can make a criminal out of any person, of any accused. And it helps me to see that the truth, the truth, is perceived through the means of evidence. If you are witch hunting, then you need to take those time-proven methods, the trial with water, trial with silver needle. I think you understand what trial with water means. A witch, a suspected witch, is tied up, and they throw that witch into the water. If the witch flows on the surface, the witch is innocent, and if the witch is drowned, then the witch is guilty. So it's actually the same. It was the same in the trials of 1930s, trials of so-called enemies to the people. We can see the technologies applied there. And they enabled the police to find as many enemies to the people as they wanted to find. So it's us who built the truth and the truth. And it's also the case with journalists. They create that virtual reality, which becomes even more important than the true reality. And the electorate, they communicate not with the live nominee, but or runner-up, but they communicate and see the images of those nominees and candidates. So the schemes that the judges sometimes use, it's the invention of motives. So there is a very accurate formula that the court trusts the evidence given at the pre-trial interrogations, because those admissions could be forced because of the wish of the accused to avoid justice. So just two men were drinking, and then one hit the other with a bottle and killed. And the investigation had to establish, and the judge has to establish motives. But they were drunk. What motives did they have? And the judge writes that, the accused killed the deceased because of the sudden circumstances, of antipathy. There is another witness who says that they were kissing each other and being drunk, and anyway, the judge removes the motive and says that that was the murder without any motive. So 20 witnesses tell the judge how the accused was drinking with them at a wedding ceremony. He was identified, and the judge writes that he trusts the police, who are not interested in the outcome of the trial, but we don't trust that 20 witnesses because they were acquainted with the accused. So 20 people is nothing, but 2 police, that's something that really matters. The other method is a kind of aggravation or exaggeration. Say there are 2 people who allegedly strangled a woman, put her body into the bag, brought it to an island in the Volga River and burnt it down. The coroner has the rope that was left on the neck of the strangled woman. And following the burning, there were some traces of sweat and fat. Forensic conclusion, the sample of the sweat were exhausted, fully used during the investigation. But we cannot rule out that fat and sweat belonged to the accused. Judge writes in the ruling, the conclusion of the court confirmed that traces of sweat and fat of the accused are seen on the body of the deceased. So the forensic writes that we can rule out that those traces belong to the accused, and the judges writes that it does. And the third method, when you put all the evidence together, it's when the judge does not differentiate the evidence of an event and the evidence of the accused being guilty. And then there comes a long list of that evidence. Just take an example of the European Court ruling in the case of Popov versus Russia. And the European Court writes that the National Court of Russia included many pieces of evidence into the list, proving that a man was killed. But there is no evidence that it was Mr. Popov who killed the person. Besides, there are some pieces of evidence on the list which has nothing to do with the case. Why did it happen? I think a judge just cut a piece of the former ruling and inserted it and just put it into his ruling. And I think I can give you some other cases when justifying pieces of evidence seen as something that prove the guilt. For instance, a young man is shirking the compulsory military service, and it's written in the non-proven evidence that the man doesn't belong to any militarist organization, and if he doesn't belong to any organization, then he has some anti-military sentiments. Okay, so, and there are some clear cases of rigging, and the court of Khabarovsk heard a case, and there was the families of Gusein, of Assad, of Aliyevs, some great criminal ring. And I think counsel for the prosecution wanted to be promoted, and they made of those families a criminal ring accused of planting some narcotic plants The court decided that, and the investigation found no evidence of a criminal ring, and the the judge writes that the arguments of the counsel for the defense against the availability of that criminal ring does not reject and refute the accusation, but substantiate it, because the evidence testifies to the conspiracy in which that informal ring operated. And Supreme Court approved of that ruling. So if you took an oath, if you are tattooed, then you are guilty. If you didn't do so, you are even more guilty. It's like that. So that's the sooth, the way judges see it, and the sooth which is created with those tricks and methods. And then we can state with great surprise that it so happens that the alleged sooth does not satisfy the people of the Russian Federation. And the people of the Russian Federation need the truth, not only that sooth, but the truth. And I cannot help but quote our great legislator, Mr. Speransky. He wrote in the 19th century that any law, and Tsarist law is the law by the justice, but it is the law by the truth. And when the truth ceases to become the basis for the justice, then the self-rule begins. I would dare give in my own definition of truth, but I admit that in the Russian culture, and Jesus Christ never mentioned anything about sooth, because he was sooth himself. And that's the reason Christian writers write that the truth is a traditional morality of the Russian people, that some special spiritual state when objective sooth coincides with the conscience of the man. That's the truth in Christian way. It's the coincidence of the spiritual sooth and the truth. The Russian people see it. And if we stop being religious, if we take a secular approach, I would say that truth is just association of people's souls with some system of values, or that's the responsiveness of some soul, of the soul to some values. So you can keep on studying, learning some sciences, but there is no response in the soul. But then you hear something and your soul responses. And Turgenev has a great poem on that, about the truth and the sooth. It's about a young man that rushes into the room with other people, and he shouts that he opened the sooth. And he was asked what was the sooth. And he says that the angle of the fall is equal to the angle of reflection. And everybody kept on drinking tea. And if he had said that Zasulish was acquitted, then he would be really taken on their heads. So truth and sooth are two different things, and it's clear that truth is, unlike sooth, truth is inside people. For instance, there is such an assumption that unawareness of the law does not relieve you from responsibility. But why? I don't read, I don't know, I'm not aware of the law. But that acts because the law is in your heart. Your brain may not know that law, but in your heart you always know that you cannot steal, you cannot wish a wife of your friend, and people may act cowardly and cunningly, but in their hearts they can always feel that. I can I understand that I should leave half an hour for Q&A, but still, I'll give you one story. I heard a case of one policeman. It was mostly illiterate man. He couldn't write even appeals. He made primitive grammar mistakes, and he was tried for double murder. And that policeman, he loved his wife very much, but his wife, was not faithful to him. And with the help of his agent, he caught two suspected lovers of his wife, brought them to his apartment and investigated them and tortured them. And after he was tired with their boring answers, he began shooting at them. He shot to death both suspected lovers. Then he wounded his agent and his wife, who tried to take that gun away from him. And then a funny thing happened to him. That policeman called up his police mates, and he said to them that he killed two people. It was the holiday day of police, and those friends of him were totally drunk. And they answered to him that, okay, so please get sober. If you can't, please come to us and have another drink. So the policeman who did that double murder disappeared from the spot, but then his conscience didn't let him live in peace, and he really surrendered himself later on. And when I asked him why he left like that and didn't change anything, he said, I couldn't, I'm a policeman, I couldn't rig evidence, and so I couldn't change the circumstances than the evidence. So I think conscience is a mechanism which inspires us to act like the truth tells you to act. And it's not accidental that Roman Emperor Mark Aurelius used to say that every person is worth of something that he cares for. And that's quite accurate, and truth can be different. If you read Rudyard Kipling's story, he has a lot of stories. He wrote about the dust from moving boots, and he has another story about a sergeant who was shot dead by a firing squad. An old sergeant quarreled with an officer. The officer tried to slap that sergeant, and the sergeant responded by hitting that officer. And the sergeant said that, I really hit and killed that officer, but he's too young to insult old sergeants. He was executed. And let's read Leo Tolstoy. Leo Tolstoy used to be an officer too. He served in artillery units, and there were stories that he used a lot of taboo words. And actually, the purpose of Tolstoy saying that taboo words was that he tried to discourage his soldiers to use those bad words. So he invented his own words, and he invented such, exclusive taboo words that he was famous for that. A soldier hit once a warrant officer, and in the field court, Leo Tolstoy was the counsel for defense, and he tried to prove that the soldier was insane at that time, but he failed, and the soldier was executed by a firing squad. And Leo Tolstoy wrote then that no laws were worth human life. That was the truth of Tolstoy, and the truth of that Kipling sergeant was that no, it's the truth that is worth everything, not people's life. So that's my definition of the truth. I really differentiate between truth and justice, because justice is associated with some compliments, while truth is not. Isaac Serene, the saint, discouraged people from calling the God, the Lord, as being just to them, because if a Lord were just to the people, he would condemn them all long ago. As for Islam, Islam is really the young religion, religion of justice. I have a collection of some very interesting stories, and one of them reads that in Saudi Arabia, a Sharia judge was riding in Mecca, and his car hit and killed a dove. He got out of the car and saw that the dove was dead, and he wrote a fine penalty for himself. And Orthodoxy, on the contrary, is by and large is the religion of love. And for us, the story of Christ is the story of Christ and the whore. So for us, when the formal law triumphs, it doesn't mean joy and justice for us. Look at the Newgate Herald of the UK. People are hanged, and the collection of stories is published, telling their stories to the people. That collection is read at schools. Mothers read that collection of stories to their children, and some parents just punish their kids with sticks on that day, just to say that the justice triumphed on that day. And that's the reason Dostoevsky kept on saying that people does not deny that there are crimes committed. People do not deny that there are criminals accused of that, but people similarly understand that they are also guilty. All are guilty. And let's look how the jury can rule in some cases. There is a city of Tomsk, and there is a certain Mrs. living with her husband, and she's worked as a conductor of a streetcar, and her husband was extremely jealous, pathologically jealous. He disguised himself and was riding. He was riding in the same streetcar, looking at his wife. And if she smiled to a stranger, he was beating her. So for several years he did that. But in 2004, he beat his wife again, as well as her mother, his mother-in-law. And then that mother-in-law splashed some gasoline on him and ignited that, and that killed him. She was taken to hospital, and to treat him, the medicine was required, which cost 1.5 million rubles, and he died in the hospital. So the jury was thinking what to do with that guy, and instead of making a verdict of being guilty or not guilty, they came to a very strange ruling, saying that it was not proved that that husband had died from his mother-in-law's actions. I talked to the people of the jury, and I found out that there was a doctor who explained to the rest of the jury that medicine was very expensive, and no hospital could afford paying $1.5 million. But it's not in the evidence, as what the doctor said. Secondly, the women in the jury said that that man had to have been killed long before that, and she tolerated him for 12 years. And third, very wonderful deliberation. It was on the Easter day, and why did he did so on Easter? And so I think that in this case the jury ruled against the truth or sooth, And they also ran against justice, no matter what husband was, but he didn't deserve death penalty. He didn't deserve death penalty for beating up his wife, and some years in prison or some corrective work. And that's what happened. But I suggest that that is the triumph of truth. Or say the Supreme Court just banned the accused of telling about tortures before the jury. And because once the defendant said that under torture he would even agree that he had crucified Jesus Christ. And from the standpoint of the jury, the state that exhorted to torture just loses the right to carry out the trial. And because it wouldn't be true if an accused is sentenced if he had been tortured before.
However, there is also what we call a particular truth or a specific truth, something that the judges believe to be an achievement of the court system, and the so-called truth of the sentencing council. What does a judge opt for? Specific standing order when you may indeed omit the proofs, and if the defendant says that he is guilty or confesses his guilt, then indeed the sentence may well be adopted. The incomplete reciting of the sentence, you read it in the beginning and at the end. But there are also honest judges, and for them the truth is a form of armed kindness. I'm traveling a lot in Russia and elsewhere, and I was in Saratov, the first Russian city where the grand jury was first reintroduced in the beginning of the 90s, in 1993. So I was having these meetings with the attorneys at law. The attorneys at law say that the justice is not following the letter of law, but rather some preconceived truths. An attorney at law has proven that the actual substance that was confiscated from a particular person was substituted with the drug. And so the attorney says that the expert conclusion is wrong. And the judge calls the attorney during the break, during the intermission, and says, your defendant, was he cooking pot? Well, then what do you want from him? Then all is right. So it is irrespective, for such judges, it is irrelevant what is the proof. Let him just get his due. Let us sentence him irrespective if the particular case has been founded on the evidence. But by in conclusion, I would like to quote a strange method of trying to analyze the consciousness of judges by considering their creative products. There are some regions where judges are publishing their poetry, their books of verse, and here it is very important to look at what is their versification efforts arrive at. So a judge of a regional court, that's a judge of my level, if you listen to this, I'm writing a sentence. I'm writing this sentence, and I'm not being at haste. But I should not be at haste, and Forsink and Filipov will be able to get away from the justice. If only the evil could be targeted with my verse, then the crime would subside. And a comment. A sentence for Fursov and Filipov case proclaimed on the 28th of April. The sentence remained unchanged. The complaint of the accused were unattended. The judge said, I have been a judge for 27 years. I have never acquitted a single person. And of course, it is well understood that the judges who work have the knowledge filters, including their specific truth or particular order. This is how I see the correlation of truth and justice in the court. If you believe, will you preside over this? Yes, indeed. Now, what do you want from this country? Quentin Tarantino is at rest. Unfortunately, the British judge is no longer with us. She would have enjoyed it immensely, I think. Yes, please. Mr. Korovin, the Tambov region. You might have heard this question a number of times, but let me still ask it. The statistics tells us for 2012 and 2013, the general statistics for acquittals is about 0.4 to 0.6%. The statistics for 1937 was 16 to 18%. Why? The question is. Well, I think that you have to see this bending point. When did the acquittals vanish as a category? With Khrushchev's thaw, and indeed the struggle for the so-called socialist legality. What was the logic of the socialist legality? If a judge were to acquit any person, he had to write about this to the Ministry of Justice, and he also had to write a reference statement to the prosecutor. This particular order, which was bound, was introduced in 1953 and then in 1954. One of the terrible reprimands, public reprimands of one of the Moscow district judges when he was heavily and harshly criticized for too many acquittals. And of course, the judges and the prosecutors were members of one of the same party organization, the Communist Party organization. And even if that were not the case, the judges were drinking vodka and spending birthdays together with the Attorney General's office representatives. And so the judge understood full well that if he reports to the Ministry of Justice about the particular prosecutor on a particular case, then he would mar his relations. So by 1956, the number of acquittals went down to 1.5%, and then was going down. In the 1970s, the stability of sentence was proclaimed. The district judges in Moscow, in Leninsky, Cheremushkinsky, Oktyabrski districts, a judge from the superior court was placed. This person was to follow or supervise the sentences. So these judges were calling the presiding judge, and the presiding judge was checking on the accuracy of the sentence. So the sentences are all very stable. The indicator of or the number of appealed and the satisfied appeals is about 2%. So we see no changes coming from the Soviet times. It is the same old story that we've seen from 1956. Mr. Khvostov from Saratov. what is the legal compensation for the mistakes of the judiciary? There are no mistakes of the judicial or court mistakes. If we're talking about the criminal cases, there is the notion of rehabilitation. When there is rehabilitation, then different amounts may be paid. There is no absolute threshold. I have known that cases when 1 month of arrest, non-justified arrest, might have equal to 100 ruble fine. Now I have known that 200,000 were paid, but the judge needs to deliberate. If I'm killed, my family will get 240,000 rubles. Why should I pay him more? A question from Poland. Szwetajek from Krakow. I do not quite understand if there is any hope for honesty, or the system in Russia is based on these very absurd notions, because it appears that we're dealing with a great level of incompetence, and I'm just is this more of a reflection of a very sad reality, or there is a good deal of humor in what you're saying? Well, our hope is for the political will of the president of this country, of person number one, which is contingent on the actual structure of justice in this country. That is why whenever I have a chance to talk, to address the President Putin, I always tell him there has never been a case in any country, I think, when in a court reform or the reform of the judiciary was initiated on a grassroots levels. This has also been coming from above, from the government, by injecting new people, resources into the judiciary. And in a way, the court system is efficient insofar that it is digesting about 1 million cases with the defendants, and millions of civil cases. In any event, the sentences are predictable, and the concerned parties understand how they can get what they need. Anna Martinova from Sochi. There's a tendency in Russia, in the Russian regions, in the Russian province, when the head of a municipality or a region talking at a meeting or some other closed-door meeting, when any urgent question about defending the rights of a municipality or a region is discussed, or when a region is a defendant in a particular case, there's often a phrase, I will call the judge and we will settle this. I will talk to the prosecutor and we'll see what can be done. What can be done to avoid such pressure on the courts? Well, it is possible to avoid the pressure over the court, because the courts and the executive are a part of the nomenclature. So the member of this apparatus may be the head of the FSB, or then go and work for the Ministry of Justice. Well, I think that at the level of municipality, it is very difficult to influence the court. I think one has to do it at the level of the governor. There, it is possible. And if the official says that he would call the judge, I think that he's bluffing. Usually, the presiding judges are being called, or when you go hunting with the presiding judge, nothing can be done except for one thing. When a particular question would be solved not by a judge who is only interested in getting a new apartment or a new car, but a representative of the people who sees the essence of the case in upholding the justice. So it is sometimes valuable to think about the honorary judges and the magistrates. The British magistrates are not paid. They're not salaried. They're not salaried judges. They don't need anything from you. A question from Armenia. And by the way, try to obtain the right of electing judges. Goar Makoyan from Armenia. The system of penitentiary system is not particularly flexible. Thus, there is a great tilt towards the sentences, and in many cases the prison terms are longer. The penitentiary establishments are overcrowded. In what way and what mechanisms could be used for us to reduce this burden on the prisons, and what should a judge be guided by in terms of the criminal law if it's a traditional society? And do you believe that there is a connection between a lower level or reduced severity of a sentence and the reduction in crimes? Norbert Wiener, the father of cybernetics, wrote that one has to understand why do you need the criminal justice. Is it for restoring the justice, decreasing the crime, or indeed the redeeming? So a decrease in the burden or in the overcrowding of prisons could well be decided by the presidential will. When President Medvedev was saying that that the prisons are overcrowded, indeed the number of prison terms were getting less in number. The second point is the so-called restoring justice, when a response to a crime is, an offense is not a punishment, but a restoring of the fabric, which is that you talk to the mediator between you talk to me. And the mediation service in the United States is quite sufficient and efficient in the small claims field for claims under $2 million and for the local offenses. And of course, the chief reasons, of course, for so many prison sentences is the extremely high number of the law enforcement agencies. You have to feed your law enforcement agencies with meat if you have such a high number of them. One other detail: the people live very poorly. The state is rich and the people are poor. So a typical system of criminal justice is that 23% is prison term, and the same number is the conventional 7 to 10% is a fine, and that's about it. So there is not much that people can pay with except for their freedom, because if a person is fined, if a person is fined and he or she does not have means to pay the fine, then he would be sent to jail eventually. Alexei Tupisin from Irkutsk. How do you regard the lustration of judges in the Ukraine? Do you believe that this could ever happen in Russia? Well, I was in Kharkov less than a month ago, and I have talked and heard a lot about the lustration. Lustration is a good thing when it is timely. If the lustration must have been done 20 years ago to get rid of the pro-Soviet judges. Now lustration is more of an instrument of political revenge, and I think that we have missed on the opportunity to conduct the lustration, unlike, say, the Eastern Europe. Our friend from a country far away. I'm Diceto Osvaldo from San Tome and Principe. I often hear that the law must not be violated, but can be circumvented. What do you think are the main ways in Russia to circumvent the law? Well, I think that the most widespread is corruption, of course. Corruption and bribery, outright bribery. But there are, of course, other judicial ways, which is I would recommend you to read a book about the unlawful deeds by the attorneys at law. There's a PhD dissertation devoted to this, tortures and corruption. Ruslan Tsuryuk from Kostroma. Up until the recent time, I was working as a chief editor-in-chief, and one of the regional departments in my region tried to take me to court. And the governor was changed, and the claim was revoked. When the judge was considering my case, I was getting an impression the judge was trying to dislodge this case. And when it was taken to Moscow, the judge seemed to be very relieved, because the judge apparently did not want to adopt a verdict which would run contrary to the law, even though it might have been in conjunction or in compliance with his feudal loyalty. That is true. If a case has been ordered for or has been solicited, but there are also other cases when a judge does not want to take a to have an acquittal. I have come across such a case when a judge preferred to have me consider the case, not to acquit anybody. You have said that you're trying to take this your opinions, to the president of Russia. Do you have any feedback? Well, Mr. Putin always tries to get prepared for the meetings with his advisors. When I talk to him on the grand jury, he usually would say that that on terrorism cases there cannot be a grand jury. But why would women or the juvenile persons be relieved? And he said, I'm signing many laws and I can't follow everything. But this draft law has been taken to the president. We'll see. My colleague from Bashkiria, Bayram Agulov from Ufa. As we all know, the Court of Arbitration is getting more and more feeble, and the practicing lawyers, especially, for instance, in Bashkiria, are often very negative minded on these processes. Has there ever been any opinion of the experts? Well, the decision was taken spontaneously and without explanations. Before 2 months before this decision was taken, you might remember the complex program was made and prepared for 2012 to 2020. The decision was taken spontaneously for some political reasons. No expert advice was sought. As far as the fact, what can we do, I think that you just have to take it. The only way for you to try and cope with this is that there will be most probably the instance of second appeal, and we'll see what comes out of it. Yes, please. Denis Machovsky from Novosibirsk. 2 months ago, we went through the elections of the mayor, and Mr. Starikov's team was able to revoke the candidacies of Yedinaya Rossiya at the level of a district. And the judge took a decision, being very short of time. The judge took a just decision, and the team of Yedinaya Rossiya did not know how to deal with this. They were collecting their meetings, and eventually they took a decision. And a district judge, when talking to a press conference, expressed an opinion about the incompetence and some what we may call what he called the mythical defamation. That's my question. What needed to be done when this regional court revoked the verdict of the lower instance?
The next step was supposed to appeal, and probably the expressions that the wording that the judge from the district court were tantamount to discipline action. And before her decisions are revoked, I suppose she can be disciplined, and appealing to the... Just two more questions. Thank you very much for this fantastic presentation and excellent examples. I understand that a good judge is the one who makes the one who is culpable. He acquits. The question is, and the other way around, does Russia have special criteria for evaluating the judges practice, and if none, then what is the global practice about this? Well, first of all, there are countries of the common law where matters of or criteria of evaluation or assessment of what the judge does, this is not on the agenda, because judge could be only undergo impeachment to be removed from office. During the entire history of judicial system in US, these impeachments were carried out only in 9 cases, so judges cannot really be revoked or replaced. Criteria evaluation either was disciplining action. This is a special branch of the judiciary deals with this. They're called discipline courts for judges, or special courts with such a procedure when the representative of the Ministry of Justice or the prosecution goes against the judge, and the higher college of magistrates sets, here's this case. This is usually the practice. In Russia, we have 2 criteria, and they're set about in the law. First, the rate at which the judge looked at her cases, and the number of abolished cases, and how many of your verdicts were returned by the Court of Appeal. Revoked by the Court of Appeal. And now the factor of loyalty. This is something that it is put down in Article 5 of the Code of Judicial Ethics. And moreover, there is a special body that oversees and ensures loyalty. This is a special commission which discusses preliminary candidatures under the President, which has law enforcement agencies, Deputy Prosecutor General, Deputy Director of FSB, Federal Security Service, and this is just to see if every candidature goes through. Anyone who quits could be suspected of corruption. Probably a normal judge is not supposed to quit, and this judge is not loyal to the law enforcement organs. This is the 3 criteria that are widely used. Dear colleagues, you know, the thing is that in principle we could just organize a trade union here that would take care about just over how we are complying with the labor legislation. Since we're not, we are really, as I'm as a moderator, have to really look after it. When you will get some rest, I will probably think that we will shorten our coffee breaks by 20 minutes. Please, I want you to understand me that otherwise we have no other choice, and I'm sure that His Honor, the judge, will support me in this decision. Dear colleagues, I suppose the school was lucky, School of Civic Education was just lucky, because Sergey Pashin is now interacting with us and is taking part in our fora. Those of you who attended a seminar in Zelenogorsk remember an excellent core hearing where this person with, psychic got sort of his verdict. So we continued, in my view, this, and we continued it with great enthusiasm. So there are really things to consider, and I believe that the purpose and the goal of this session has been met, has been fully met. We shall continue to work on this problem again, and I'm confident that we shall continue to invite Sergey Pashin to speak here before our audience at the seminar. I cannot say I'm sure that the judge would acquiesce, but this is where you could really go you can really go. And thank you. Let us give a round of applause to our expert. I wish to thank the interpreters. Dear colleagues, everybody is free. This is a standard joke, because this is what is the usual procedure in law enforcement when they release you. They say thank you.